Life over death. Abolition of death penalty should be the core of any reform in justice system. It is disappointing that parliamentary committee that examined the Bhartiya Nyay Sanhita, the proposed criminal statute likely to replace the IPC Indian Penal Code, has not made a recommendation to abolish the death penalty. Instead, the Standing Committee on Home Affairs, despite submission from experts and jurists on abolition, choose to make blunt, dull recommendation that the matter may be left for the government to consider. Its observation is limited to a remark that it has understood that the reason for a passionate argument against the death penalty is that the judicial system can be fallible and to prevent an innocent person from being wrongly sentenced to death. However, domain experts had made some persuasive submissions before the panel that instances for trial court awarding death were on the rise, whereas statistical trends shows that Supreme Court of India was leaning away from the capital punishment. The social scientists had demonstrated it had no deterrent effect and the global opinion was in favor of its abolition. The court awarded death penalty to only 7 people from 2007 to 2022. While all death sentences were either set aside or commuted to life in 2023, as they did not fall under rarest of the rare case. Members who added notes of dissent to the report also highlighted the argument that capital punishment has been shown to be no deterrent, that imprisonments for the remainder of convicts' natural life will be a more rigorous punishment and more scope for reform, and that most of those on death row came from unprivileged backgrounds. They have also made the point that the 3 bills proposing a new body of criminal law are substantially the same as existing IPC, Indian Penal Code, Code of Criminal Procedure and Evidence Act. If at all parliamentary moves to enact the draft bill with the change suggested by parliamentary panel, it will be in the fitness of things if it is used as an occasion to reconsider the need to retain the death penalty. The BNS has defined life imprisonment as the term for the remainder of one's natural life. This should be the default alternative to death sentences. The case for abolition will gain strength if the trends of seeking premature release of the life convicts on political ground is arrested and life term without remission become more common. Remission should be a humanitarian act and never a source of political controversy. Removing capital punishment from the statute book and introducing a rational and universal remission policy will be a substantive reform in judicial system.